Has the Supreme Court's interpretation of the Equal Protection Clause changed since Brown?
Yeah, it's gone beyond racial segregation to tackle other kinds of formal inequality. So, for example, in the 1970s through today, the Supreme Court has addressed the question of when, if ever, it's permissible for government to treat people differently on account of gender. It has addressed laws that treat children differently depending on whether they were born in or out of wedlock. It has addressed laws that treat people differently based on their sexual orientation or their age or their physical disability. It's also, within the area of race, had to take up the question of whether so-called benign use of race, i.e. affirmative action, where you're using race not to keep racial minorities out of all white institutions, but rather trying to use race to integrate those institutions by giving racial minority candidates a preference or a plus at the admission stage, whether that's okay under the Equal Protection Clause. Even if segregation is not okay, is it okay to use race in an integrative way?
Are you saying that laws inevitably create classifications or categories of people? Is that fair to say?
Yeah, I think it is. If you try to imagine for yourself any law in the world, if you think long enough and hard enough, you'll realize that the law treats something or somebody differently than something or somebody else. Otherwise, it doesn't do anything. Every law has to sort in some way, and it's inherent in the process of sorting or classifying that you're creating technical inequalities, which is why I said earlier, the question isn't whether a law treats people unequally, it's whether a law treats people unequally based on some impermissible criterion or some illicit reason.
So when a court is examining one of these classifications to see if it's impermissible, there are different levels of analysis that courts use. Can you describe them for us?
Sure. The court breaks equal protection analysis down into tiers or levels of scrutiny or skepticism. So if a law makes use of race, if it formally sorts people based on race, and that's true whether it's trying to segregate by race or trying to integrate by race, if it takes race into account, if the race of an individual is relevant to the implementation of the government policy, then it is a race-based law and it is subject to what we call strict scrutiny, which is the highest and most skeptical form of scrutiny. It's like fundamental rights under substantive due process. The government has to come up with a very strong reason for being able to do that. In between are classifications where the government has to come up with a good reason but not an absolutely compelling reason. We call that intermediate scrutiny, and I'll give you an example of that, laws that treat people differently based on gender. So a lot of laws that treat men and women differently are going to be unconstitutional. A law that says women can't attend military academy is going to be unconstitutional. But on the other hand, a law that treats men and women differently for public bathrooms, single-sex bathrooms, that's not unconstitutional, even though single-race bathrooms would be. So gender is something that triggers suspicion, but not quite the same as race. And then most everything else currently is treated under a much more deferential standard of review known as minimum rationality review, in which the government doesn't have to have much of a reason at all, and the courts are not skeptical at all. So, for example, a law that imposes a tax on some transactions and not others, a luxury tax on people who buy yachts, that treats people who buy yachts differently than people who don't, but that's not the kind of classification or unequal treatment that causes the courts much concern.
Are you aware of any race-based law that has survived strict scrutiny?
Sure. In the year 2003, the Supreme Court upheld the University of Michigan's use of race in law school application processing as long as it was done on a very careful, individualized basis in a way that didn't crowd out all the other admissions criteria. So that's a real-world example. Let me give you a hypothetical example. If you were in a prison and there's about to be a race riot that's going to break out, the warden probably could temporarily segregate prisoners on account of race until she or he had time to sort things out. Couldn't do it for very long, but as a temporary measure probably could. Here's another common real-world life example. When the police decide whom to stop after a crime has been committed based on a witness's description, that description includes race. So if a crime is committed and there's a description of the assailant as being someone who looks South Asian, 5'11", 180 pounds, in his 40s or early 50s, I'm going to get stopped and you're not, even though part of the reason I'm being stopped is because there's a small element of racial profiling that's okay in the context of a larger description.